Hello, I'm Judge Challenger, and I've been a judge in small claims court for 12 years. In this video, you will learn about how civil lawsuits for less than $25,000 move through BC's Small Claims Court, which is a division of the Provincial Court of British Columbia. Most people who appear in small claims court represent themselves. If you will be representing yourself in court, you will need to understand the court process. You will need to learn about the court system, the law that relates to your case, the rules of the court forms that must be used, what you and the other side need to prove, and the possible legal arguments for your case. This knowledge will also be helpful if you do hire a lawyer to represent you in court. In British Columbia, the process required to advance your case through small claims court depends on the location of the courthouse where the claim is filed. For example, the process is different for a claim filed in Vancouver compared to one filed in Victoria. This table provides a simple overview of the court processes for the small claims court in your area. This table might not seem so easy to understand at first, but once we take a look at some of the steps in the process, it will all become more clear to you. To start, let's take a look at a sample case. It's just a fictional example, but it will help to explain court processes in small claims court.
My name is Sarah, and I own a building in Richmond that has a glass awning in the front over a set of windows. When it was time to replace the awning, I called a few professional contractors. I chose a contractor named John because he had over 10 years of experience installing awnings, and he showed me pictures of glass awnings that he had installed. He seemed professional and experienced. When I talked to John about the job, I showed him the old awning and told him that I wanted the new awning to look exactly the same as the old awning. I instructed John to take pictures and to measure each piece as he removed the old awning. We agreed on a price of $12,000, and I signed a contract for him to do the work.
My name is John, and I'm the contractor hired by Sarah to install a glass awning on the front of her building. Once we agreed to the terms and signed a contract, I ordered all of the parts and assembled her awning at my shop. But while I was installing her awning, she said that it did not look close enough to the original awning and told me to stop working. I told her she would have to pay me the $12,000 because I had already bought all the materials and built her awning. She refused to pay, so I had no choice but to sue her in the small claim court. That makes me the claimant in the case and Sarah is the defendant.
Since this civil dispute involves an amount less than $25,000, it will be heard in small claims court. If it were for an amount over $25,000, it would be heard in the BC Supreme Court. To advance a case in any court in British Columbia, claimants and defendants must use standard court forms. These forms must be submitted within a certain time frame. They must include the number of copies indicated on the bottom of the form. They must be signed, dated, and in most cases, served on the other party. This means that the other party must receive a copy. The form that starts all small claims court cases is called the Notice of Claim. It is completed by the claimant. In our example, that is John.
I used the smallclaimsbc.ca website to complete the Notice of Claim form. A short video helped me understand how to complete it. Once I had spent a little time with the form, it was pretty easy to understand. I completed the form on the website, then I printed out the proper number of copies and I took it to the Court of Registry in Richmond.
In court cases, it is important for both the defendant and the claimant to be informed of what is happening. To ensure a fair trial, both parties are required to notify each other and share information about the claim. In a lawsuit, getting the paperwork from one person to the other is called serving documents. Once John filed the notice of claim at the Richmond Court Registry, He served it on Sarah by sending her a copy by registered mail to her residential address. There are rules about serving documents that must be followed in order for the court to decide that the defendant and the claimant have received all the necessary documents. You can prove that you have served the document by filing a certificate of service, which explains what documents were served, to whom, and how and when they were delivered. For more information about serving documents for small claims court, read the guidebook, Serving Documents.
So, I received a registered letter from John, and inside was this notice of claim. It explains that John is suing me in small claims court, and now I have 14 days to reply because I was served in the province of British Columbia. Had I been served outside BC, I would have had 30 days. On John's second day of work, I discovered that the new awning he was installing was the wrong size and shape. It was not the same as my previous awning. So I told John to stop working because he was installing the wrong awning. He said I would still have to pay him, but I refused because he was not installing the awning I wanted. Now he is suing me. I am not going to pay him for something I didn't buy. So I will reply to this notice of claim and prepare to defend myself.
In this example, John filed the notice of claim in Richmond, and so the court process for Richmond will apply. If John and Sarah don't settle their case before they go to trial, they will first attend a settlement conference, then a pretrial conference, and finally they will go to trial. I'll explain each of these steps in this video. Sarah filed her reply to the notice of claim and served the document on John. The next step is for them to receive a date to attend a settlement conference. In almost all small claims court cases, there is a settlement conference before the case goes to trial. One exception is a motor vehicle accident case where liability for damages is being disputed. That case would go directly to trial. There are other special rules for personal injury claims, so be sure to review the court rules or ask the small claims registrar to make sure you are following the correct process. The settlement conference is only between the judge, the parties involved, and a clerk who takes notes. The public is not allowed to attend. In most small claims court cases, the claimant and the defendant represent themselves and present their own cases. This means that both the claimant and the defendant have to prepare for the settlement conference. If either party has a good reason to postpone the conference to another date, you will need to follow the specific processes and file specific documents with the court registry. Generally, this notice or documentation must be filed with the court at least 7 days before the date set for the conference. If the claimant misses the conference, his or her case could be dismissed. If the defendant misses the conference, then the judge could make an order requiring him or her to pay the full amount of the claim. In both cases, the judge could also order that the case go directly to trial.
After I filed the notice of claim and served it on Sarah, I received her reply, which she served on me. Sarah claims that I was supposed to build her awning exactly like the old one, but it couldn't be exactly the same. How I have just received a notice from the court about attending a settlement conference, Sarah and I are going to meet with a judge to see if there is some way we can settle. For me, the best settlement of this case would be to finish the job. And if I can't finish, she would still have to pay because the materials can only be used for this awning.
Well, John is still suing me. We now have a date for a settlement conference. I am going to have to start to prepare to meet the judge and explain my position.
At the settlement conference, the judge will ask both parties to give a short summary of their cases. Both parties should be able to clearly explain their cases and describe what supporting evidence they can present in court. The judge is trying to determine if there is a possibility for the parties to settle their claim without going to trial. The judge will review the laws that apply in the case and will discuss with both parties the evidence they intend to present. All right, thank you, John and Sarah, for appearing before me today. We're here to talk about your dispute where John was to remove an old glass awning owned by you, Sarah, and replace it by installing a new glass awning. And this was at your property at 777 Plain Street. John, since you're the claimant, why don't you start by explaining to me what happened and why there is a dispute?
On November 3rd, I received a phone call from Sarah asking me about glass awning.
A settlement conference gives each party a chance to explain his or her position. Evidence and witnesses are not presented.
There are two parts to my case. First, I will prove that Sarah is liable, and second, I will prove that the $12,000 damages are justified.
Your Honor, when I hired John, I explained to him that I wanted the new awning to be identical to the old awning. I have pictures as well as the original drawings that show the size, placement, and style of the previous awning.
Once both parties have presented their case, I usually try to get them to discuss things that they agree on. In this case, both John and Sarah agree that the contract was for $12,000, that Sarah requested John to stop the installation, and that Sarah refuses to make any payment to John.
You're right, Your Honor. We both agree on these points. The contracted amount was $12,000, and to date, I have not paid John anything. My position is that John did not fulfill an important term of the contract to replace my previous awning like a new one, like the previous awning, and therefore I have no obligation to pay him.
Your Honor, I was installing a new awning like the previous one. When she told me to stop working, I ordered materials specifically for this job and I scheduled my time to do it. Instead of doing a $12,000 job, I have over $7,000 expenses and no revenue for the weeks it was going to take to install.
If the parties cannot resolve the case at the settlement conference, they may be able to identify issues that will help them to make the trial easier, quicker, and less expensive. The settlement conference also provides the claimant and the defendant with the opportunity to ask the judge some questions about preparing for trial. For example, the judge may be asked to prepare orders that force one party to produce documents that are relevant to the case. If the settlement conference goes well, the parties agree to resolve their case without going to trial. In these circumstances, a judge would make an order that reflects the agreed upon decision, and that would be the end of the case. However, if the parties cannot agree on all the issues, their case will go to trial. The judge can narrow the issues, make disclosure orders, and help both parties to prepare for trial. There are two options at this point. In some courts, if the judge feels like the trial will take less than half a day, he or she may decide to move the case directly to trial. However, in most cases, before the trial, there is a trial preparation settlement conference. This is also called a pretrial conference. At the pretrial conference, the judge will ask the parties about the evidence they intend to present and how many witnesses they expect to put on the stand. The judge asks these questions to estimate how long the trial might be. The pretrial conference also provides both parties with the opportunity to ask the judge questions before their matter goes to trial. The judge at a settlement conference will not be the judge at trial, if a trial is necessary.
Sarah and I agreed on a few things at the settlement conference, but we did not agree that she owed me $12,000. I'm not very optimistic we will work it out, but there is still a chance. To avoid trial, we can settle the case out of court within 30 days of settlement conference.
In our example, John and Sarah were not able to resolve their dispute on their own, and they were not able to find agreement at the settlement conference. Their case will go to trial. Before the trial, it is important for both parties to prepare. To get a successful result at trial, you must be well organized. While the judge may help you with simple procedural matters, he or she will not organize your evidence for you, will not help you to understand the law, and will not advise you on evidence you need to prove your case. One helpful way to prepare is to review the Getting Ready for Court checklist and to complete the Getting Ready for Court worksheet. The worksheet helps both parties to lay out the key facts in the case and describe evidence and witness testimony.
John and I now have a scheduled trial date. I'm going to have to prepare, even though I know I'm right. My case revolves around the fact that I instructed John to replace the old awning with a new awning, like the old one. I will gather pictures of the old awning, and I took a few pictures of the work that John was doing. Anyone can see that they are not the same. Plus, I have pictures of the new awning that I had another supplier install. It's exactly like the old awning, which is all I wanted in the first place.
Small claims trials are much more formal than a settlement conference or pretrial conference. Trials are open to the public. Both parties present their cases and evidence is given by witnesses who testify in court under oath. Rules of evidence establish what facts can be presented to the court and how to do so. The rules also help the trial run smoothly and efficiently in a predictable way. For example, they set out what documents will be admitted into evidence, whether they must be served on the other party, the time limits for doing so, whether the evidence is relevant to what is being disputed, and whether there is a rule that excludes certain evidence. Evidence also has to be believable and creditable to be accepted and considered by the judge. At the trial, there are 3 types of evidence that can be introduced: oral testimony by a witness or the parties, documentary evidence introduced by a witness or one of the parties, and photographs introduced by the person who took them. In court, the claimant is responsible for proving the facts that support his or her case. Civil cases are decided based on the balance of probabilities. This means that the judge must decide what is most likely to be true. This is not like a criminal trial where someone is found guilty or not guilty beyond a reasonable doubt. If for some good reason you cannot attend your trial on the date set, you can appear in court to ask the judge to postpone or adjourn your trial. The application must be in writing, and you have to serve the other party with it at least 7 days before you ask the judge. Fees may be attached if you ask for the adjournment less than 30 days before the trial date. Along with gathering evidence and preparing yourself for trial, you will also need to prepare your witnesses. Each witness must have personal knowledge of the facts you want them to tell the court. Hearsay evidence is something that a witness only knows from hearing someone else say it and may not be admissible in court. Prepare questions for your witnesses and go over them before trial. Avoid asking questions that suggest the right answer, as these are called leading questions and are not allowed in direct examination. For instance, instead of asking, "Was the light red?" you would ask, "What color was the light?" It is all right to discuss the case with your witnesses, but it is not all right to tell them what to say. The other party may ask your witness if they discuss the case with you, and it is all right for the witness to answer yes to this question. Be careful not to script your witness's answers or to influence or change his or her evidence. If both you and the other party have several witnesses, the judge may tell them to wait outside the courtroom until they are called. This prevents witnesses from changing their testimony to match what they have heard in court. Sometimes you may want to call an expert as a witness. An expert is someone qualified with special knowledge, skill, training, and experience, like an engineer or a doctor. If you have an expert witness, he or she is only allowed to give evidence about his or her opinion. For instance, a roofing expert may give evidence as to why a roof leaks. If you intend to call an expert witness, you must serve the other party with a summary of the opinion at least 30 days in advance of the trial. If you don't, the judge may not give you permission to call the witness, the trial may be delayed, and you may have to pay the expenses of the other party for showing up for a trial that does not finish. If you do not intend to call the expert to testify in court, you can still use the expert's opinion if you serve a copy of the expert's report or letter on the other party at least 30 days before the court date. The report or letter must state the expert's qualifications, what the opinion is, and the facts the opinion is based on. If you receive an expert report from the other party and you want to cross-examine the expert witness, you can notify the other party in writing at least 14 days before the trial that you require the expert to attend. However, be careful with this because the judge at trial may find it was unnecessary to have the expert testify in person, and you may end up paying the costs of bringing the expert to court. Another example of when you do not have to call your witness in person is when you submit as evidence a written estimate for the repair of damage or value of property. You have to serve it on the other party at least 14 days before the trial, or risk having the evidence not allowed or the trial postponed because you did not serve notice. Then you might have to pay the costs of the other party. You may want to get more than one estimate if the amount is large. Most witnesses will agree to come to court voluntarily, but if not, you can get a summons at the court registry. You need to serve it on the witness along with reasonable travel expenses at least 7 days before the court date. Then the witness will be required by law to come to testify.
I had never been to court, so before my court date, I went to the courthouse to watch some other trials and learn how small claim court works. It was good to see how the cases proceed. When you give your evidence, no one asks you questions, so you simply stand and tell your story in a clear and logical way. Watching a few trials really helped me to prepare my case for court.
Getting your case organized is the most important thing you can do to prepare for court. But, like John, you may also find it helpful to visit the courthouse and sit in on some small claims court trials. Knowing what to expect will help you feel comfortable when it's time for you to present your case. Good luck.